Hey everyone, welcome back to Fitz in Law School. I'm Fitz, and we are going to be talking about a couple of general topics today. Sitting here in my apartment in San Francisco and slowly trying to not suffocate to death because of all the smoke in the air. I really hope everyone is all safe and out of the way of the fire. I'm sure we'll get it handled and under control pretty soon. Also, the midterm elections are over. Congratulations to everyone who won. Congratulations to everyone who voted. There was an enormous turnout all across the country, and that's pretty fantastic. So, good work. Democracy. Yay. Rule of law. It's all good. So, last week, we basically finished up the introduction process into law school. We got you through the applications. We got you through selecting a school. We got you through your orientation week 1. And now, hopefully, you're getting into the groove. You know, you're starting to read your books. You're starting to read cases. You're starting to kind of recognize what the flow of law school is going to be. And it basically is the same thing. You walk in, you talk about the ideas. Class participation is, sometimes it varies from class to class. A lot of times teachers really have a interesting system when it comes to being called upon. I really liked cold calling. I really liked coming into each class and really hoping to be called upon. And a lot of times I actually wasn't really cold called upon because I participated so much in class anyway. So I mean that might be, if you're really absolutely terrified of getting cold called on, then participate a lot. But lots of teachers have, different techniques for doing that. I know one of the teachers that I don't actually have, but one of the teachers, she has just index cards with everyone's picture and everyone's name on it. And she goes through it, and every single day she shuffles it and then selects someone else. So you could get called on 2 days in a row. So it's always good motivation to really make sure to know that material every single day. So today I thought I want it to be a little bit of a shorter video. I don't really have anything too planned. What I kind of wanted to talk about was, because I was not expecting each of these videos to kind of take a long time. I know I started this process about halfway through the semester, and so what I wanted to do was I wanted to spend 5 or 6 weeks going straight on through and talking about the introduction process into law school, and then from there each week doing okay, here's what I learned this week, all that stuff. I think what I'm going to do, because I only have 2 weeks left in the semester, so this week, or this coming week, and then only 2 days next week. So, and then after that, a small break reading period where I get to enjoy Thanksgiving for 1 day, and then it's right back to studying. And then each week after that, I have one final, and I finish up in December. So I think what I want to do is I want to just talk really, really generally about the my 4 classes that I took this semester. And so I think today what I really want to talk about is I want to talk about torts. So torts, you'll hear a lot about torts and tort law and all that stuff. And torts are a really, really fascinating thing. Essentially what it is it's any law that kind of results in, or any legal action that kind of results in an injury to you that is not criminal in activity. So usually that comes along with negligence, with intentional torts, intentionally hurting someone that's not really a criminal charge, or they're usually a lot of times paired with criminal charges, or it's things like defamation or intentional infliction of emotional harm, those kinds of things. So I just kind of wanted to go through the class and talk about exactly what we learned for a short period of time, so this will gonna kind of give you a little bit of an idea of what torts is going to be about. And I'd say 99% of the time, this is also going to be your, in your first year, if not your first semester, then your first year of law school. Essentially, in law school, every single law student takes the same courses in their first year. And then after that, that's when you start to kind of get into a little bit of a selection process. So, yeah, like I said, torts is these, it's like it's they're reckless or negligent actions. They're things that result in the injury of another person, and the way that our legal system has decided to essentially heal that, wrong that right, is by giving money. So it's awarding money, it's awarding damages. So when you hear damages, or I got into a car accident and the person just, negligently, rode across the road or something like that, and I got hit by a car, that's tort action. That's essentially what that is. And the large portion of what we were talking about this semester was talking about negligence. And so negligence has 5 parts to it. And each of those parts are, like, the first one is, all right, so let's just go through the 5 parts. So first part is duty. And so a duty is essentially, is there something that it's the first step in the entire negligence process? Was there some sort of duty that this person had to me, which we could then start to talk about, they resulted negligently, and because they had a duty towards me, therefore they owe me money because they, they breached that duty. And so the absolute most general thing in the world is essentially a general duty of care. It's what we owe to one another as we exist together in life, in society. The general expectation that you will act in a reasonable manner, and this is where, like, the reasonable person standard comes in, and you say, okay, in real life, would a reasonable person do that? If not, then there you go. But that's for non-specialized, situations in which, like, there's nothing else that's linking these two people except for general duty. Like, for example, if you're in a hospital and you're a patient in that hospital, then the doctor has not only general duty of care, but then they also have a specific duty of care, like a special duty. I mean, it could be an implied what is it called? Essentially, like, they're accepting responsibility about you. Voluntarily assumption of duty. That's what it is. They could also have a contractual obligation. You went and you're a patient here, so therefore we have a duty to act in a specific way. I'm a doctor, so I need to not only perform everything with your consent, but then also give you the information of what you would reasonably expect a doctor to give, and what you would read, what a normal, layman would reasonably expect them to give you. There's also, and then there's certain things that are like exceptions to the general duty. And so exceptions to the general duty, a couple of them are like, easy ones, like you're a minor, so you don't really understand what you're doing. And then, of course, there's exceptions to that, actually. Like, one of the exceptions, if you're a minor, is if you're, like, reasonably skilled at the thing that you're doing, like, you have more experience. Like, for example, and when you talk about exceptions to the minor care duty, you're going to talk about the snowmobile case. But essentially what that is like, a kid has a gun and accidentally shoots someone or something, and you say, okay, that's a child, all that stuff, and then the other side stops and flags and says, hold on, this kid has actually been holding guns, he's 14 years old, but he's been shooting, he's like a prodigy professional shooter or something like that, and he's won 1,000 shooting competitions, and he started when he was 10, and so he has, like, exceptional experience with this, and so he knows the proper, like, you have to demonstrate that he really does understand and knows what he's doing, and he acted negligently in this way. And so it's essentially like exceptional skills, or it's an adult task. It's an adult thing that you're doing. And so the snowmobile case is like the kid went and he was on a snowmobile, I think, like with someone else, or he hit someone else or whatever, but he injured another minor. And then I think the trial court said, well, he's a minor, so too bad. And then the appeals court said, no, hold on just a second. This is an inherently dangerous activity. And so because a minor was doing an adult activity, he should be tried as an adult. There's other things like things that go and allow you to not be, or like get out of the general duty. Like you have physical disabilities. There's a couple others, but essentially you start out on a normal duty of care, and then from there, the extenuating circumstances get weighed to say, okay, are they, like, should they be held to that standard, should they not? So next in negligence, we are talking about, so duty. You have a duty, you've established that duty, fantastic. The second one is breach of that duty. And so the breach of that duty, there's a lot of different ways that you can go and analyze the breach. A lot of times it's fairly simple, like saying there was a statute, there is a law on the books, and you didn't follow the law, therefore that's a breach. That's actually something called negligence per se, which is, that's exactly what it sounds like. It's if there's no legal question, there's no real argument, there's no anything. It's if you violate the statute, then that's negligence per se. So essentially you get charged with whatever on top of the violation of the statute does, and you also get charged with negligence per se, because it just, negligence per se, I believe prima facie is on its face, but negligence per se is just, it's obvious, it's right there. So when you don't violate a statute, when you violate a general duty of care or a special duty or a limited duty, something like that, then that's where the argument comes in, that the breach was or that what you did compared to what your duty was, and then that resulting in an injury was a breach. And so, like, one of the most popular ways to really do this is to use the Hand formula, okay? So, the Hand formula is named after this judge called Learned Hand. I know, I cannot believe that's his name, but it is, and it's freaking hilarious. And one of my classmates for Halloween dressed up as Learned Hand. And if you ever, get a chance, just get on Google and look up his picture, because he just has these amazing, incredibly thick eyebrows. And I always found that, I guess I didn't really know that was him until I saw it on the internet, and I just thought that was hilarious. But he came up with this formula. He was a New York judge, I believe, but he came up with this fantastic formula that is still used today in negligence case, but in a lot of different things. And essentially what it is it's let's see here. Let's see if I can remember this. Right. So what it is it's it's a greater than or equal to kind of a thing, and it's greater than, equal to, or less than equation. But basically what it is P and then less than, greater than, or equal to, and then P times L. And so essentially what that means is B is the invest, like how much usually what happens with negligence is something goes wrong. Like a lot of times it's this particular part of a boat was negligently maintained. You didn't have someone on duty. No, it's something that's quantifiable. You didn't have a lifeguard there in the pool. No, you didn't have like a sign warning people of certain things. It's all these kinds of things that can kind of be broken down into a financial number, an actual number. Like, this is how much it would cost you to invest against the what happened in this case, and that's also why it's kind of difficult to apply. A lot of times it's something that's a little bit less connected to money. Like sometimes this would these negligent actions actually result in people dying, and this formula sometimes says, okay, what's the cost of a human life? And that's hard to do. I know that there are some legal fields that do say, no, the cost of a human life is $500,000. Like, and that's kind of hard to say. But there are other things that say this is incalculable. We can't really do this. So usually it's a little bit more applicable when it's like, an injury. I have $1,000 in medical expenses. That's an easily quantifiable thing. There should have been a guardrail here. So that's an easily quantifiable thing. And so it's B, which is the amount of investment in preventing that injury, and whether or not that is greater than or less than or equal to the probability of the accident happening, or like the injury happening, and then times its magnitude. So how serious would it be if it did happen? So if you have a tiny investment, something that says hey, if you would have added a little lock to this door, then the lock cost, $50, then that wouldn't have, then that would have solved the entire problem, and that wouldn't have allowed, say, a kid to walk into a power plant or something like that. And then if they did, the kid died and the power grid went down and all this stuff. And so they say, so there was about $1 million worth of damages here compared to a $50 lock that you could have purchased. So that essentially indicates, if the investment is smaller than the amount of damages, or the potential and the severity of the damages, then that means that was a clear breach of duty. And if it's not, if it's the opposite, the amount of damages is inconsequential. In order to solve this problem, we would have to change the entire design of our car, and that would be hundreds of millions of dollars. And the result would be, it would be like a 1% likelier chance of someone being safe in a car. That's not worth it. And so it's callous, it's this and that. Some things you can easily apply it to, some things you can't. But that's just like one of the easiest ways to kind of talk about breach. So next element is something called causation. And so there are kind of two ways that lawyers really think about causation, and judges really think about causation. One is but-for causation, and one is substantial factor. But-for used to kind of be the way to do it, and now we've moved a little bit more towards substantial factor, and that's really a pretty easy way, or a pretty easy thing to think about. This, like, here's like the negligent action, and then here's the injury. And so the only reason, or not the only reason, but like the absolutely determining factor, I would not have been injured had this not have happened. Had you not done that action that was negligent, I would not have been injured. And that's hard to prove, because life is messy, life is complicated. There's 1,000 different reasons why you do something that, you're driving down the street and you get hit by a car or something like that. And they, like, you can easily say, I don't know, like, is there only one clear reason that, absolutely no intervening force, no anything that resulted in you being hit by a car? And so it's hard to prove that was the one thing. And so that's why the legal field has kind of started to move towards a substantial factor. This might have not been the only one, but this, it's more than 50%. It's a substantial factor in me being injured. The next element in negligence is scope of liability, which is kind of similar to causation in that it is foreseeable. Essentially, that's all what scope of liability boils down to, is how foreseeable was the injury due to your negligence. If you were negligent in this case, if you didn't invest yourself in or didn't invest in the safety precautions, all that stuff, how foreseeable was the injury that took place due to that negligence? Before the injury happened, did you think, oh, well, okay, so we need to be careful because it's very clear that this could very easily result in someone's injury, so like we need to be careful. If you have like training materials for your company, and then at the bottom of the slide for that particular section it says be careful because this could easily result in injury, there are many different ways to kind of indicate how foreseeable it is. If you run a power plant, and or if you run like a chemical plant or something, and then like 100 yards away is a water treatment facility, then that you might have a meltdown or an explosion or something like that, and then the chemicals go and get into that water treatment plant, that's extremely foreseeable. So it's these things to kind of realize what is within the scope. And there's lots of different really, really interesting factors about that. Like, for example, there's this one case where this guy it was after a snowstorm. He was sitting in his truck or his car or whatever, and as a snowplow so he was parked on the side of the street, and so a snowplow was coming like this and was going right by him. And so apparently the snowplow, boom, went and like hit his car, and so his car was just jostled a little bit, and he got, I think I've already mentioned this in a yeah, I have in another video. It just hasn't been released yet, but with scope of liability, and he went and he got his pinky jammed or whatever, and that was it. That was the only injury he had. And so he went and he sued the city for cost of his car being like kind of jostled and I don't know, like the side scraped up and stuff, and then his pinky injury. So then after that, however, his pinky got worse and worse and worse, and then it got infected, and then all these things, and then they ended up having to amputate his pinky, I think. And the big thing about that was saying, okay, the initial injury and the damage to your car, driving a snowplow down the road, that's like foreseeable. That's within the scope, was clearly within the scope of the injury that was inflicted, you know? However, the city was saying, whoa, 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 whoa. How the hell were we supposed to know that the pinky would get infected, and then after that they would have to amputate it? And they said, how is that within scope? And so, at least in California, the judge said, no, sorry, okay, this was kind of a but-for issue, and you are responsible for any and all medical costs that arise out of the injury that you created. So that means that the amputation and the infection, yeah, that's also in there. Even though all you guys did was bash the side of his car, nope, sorry, you're also responsible for that. And so again, I'm going really quick throughout this whole thing, but there's a lot of exceptions, there's a lot of rules, there's a lot of really, really interesting things, and you'll learn it as you study more. And then the last one is damages. That's the last real, big element of negligence. And essentially that's covering, it's this idea that we are going to use money to make the person whole again when they suffered from an injury. They have to clearly suffer an injury, they have to identify the parties that were responsible, and then they have to be, somehow be made whole again. I mean, that's essentially what we do, is we just throw money at the problem. And then there's lots of different damages. There is damages that are clearly like connected to the person. There's like medical expenses, and there's punitive damages. And punitive damages are used to punish the party for their negligence, essentially. And yeah, and there are lots of different things. So, and that's just one. I would say probably the main focus that we had in our torts class this semester was talking about negligence and understanding negligence in kind of a tort field. So yeah, I think, yeah, probably next week let's talk about contracts, because contracts are also a very, very interesting thing, and probably something that I'm going to go a lot into later in my career. But yeah, I hope you all enjoyed this video, and have a great week. And I guess Thanksgiving is coming up, so make sure to have lots of great turkey and great food. All right, see you later, everyone.